Hello, business law students. This is Mrs. Politsky, and I have your notes for Chapter 7, Section 2 Mistakes, Misrepresentations, and Fraud. And we're going to start with talking about a unilateral mistake. And you might remember back when we talked about unilateral contracts, anytime that we have a unilateral mistake, we have a situation where one party holds an incorrect belief about some fact related to the contract. It might be the date, it might be the terms, it might be the price, but it's only on one end of the contract, not both parties. So it could lend itself to a situation where you have a situation where it's a recognized situation where if the major, which is kind of the individual who is developing the contract, and the other party to the contract is aware of a mistake, a court may grant rescission to an injured party. You may have a situation where you might have a problem where it's induced, where one party has encouraged or induced the other party to make a mistake. And thus, the contract would be voidable. In other words, you could get out of the contract, meaning that there is some term there that is misunderstood and because it's wrong. You can have a situation where maybe you just didn't pay attention to the terms, and thus you might not be able to get out of the contract. Hence, the idea that ignorance of the law is no excuse. In other words, failure to read a contract does not, in most cases, relieve the signer from any liability, meaning they're responsible for the terms of the contract. Persons are ordinarily bound by the contract that they signed, even if they were careless or negligent in reading it or failed to read it. So, anytime that you see those terms that come from companies like Apple or Google about your account, yeah, you might not read those emails that might come to you, but if you are a party to that, it might not hurt to take a look at some of those terms. Mutual mistakes are sometimes a situation where you might refer to it as a bilateral mistake, meaning that both parties have an incorrect belief about an important fact, maybe the date is off, or maybe the money that's being put down, but both sides have an issue there. It might be a material fact, meaning an important fact that influences the party's decision about the contract, meaning that when they're going to see a product arriving or whatnot. Mistakes about the subject matter. Uh, this is a situation which makes the contract void, even if for a lack of general or genuine agreement. So if you have the wrong item written down. So if I'm buying a car, but they've got the wrong model and they've got the wrong color and maybe even the wrong VIN number, that would be a voidable contract because I'm not buying what I thought I was going to buy. All right, mistakes of the law. Um, this may still result in a valid contract depending on the state. And again, sometimes laws regarding certain business practices sometimes get updated or changed by the government, and it might be a situation where people didn't realize the law had been rewritten or changed, but it still may be a valid contract in one way or another. All right, what is misrepresentation? Well, there can be an innocent misrepresentation where a party to a contract does not know what statement he or she has made is actually untrue. So I might be a sales clerk and somebody might ask about a product that I'm selling if it's been damaged. If I don't know what the whole state of the shipping process was, I might not know I'm selling a damaged product, and hence that would be an innocent misrepresentation. Then the other is the fraudulent misrepresentation, where the party to the contract knows that the statement that he or she has made is untrue. Where maybe I have a vehicle on my car lot that I'm trying to sell, but it's been in a fender bender, it's been in an accident, but I tried to sell it as there was no accident. And I lead people to believe that the car hasn't had any, you know, issues, been in the shop or anything like that, and I would be obviously lying. To be misrepresent or to have elements of misrepresentation, you've got to have the following: the untrue statement is one of fact, or there is an act of concealment as far as trying to hide something. The statement is material to the transaction or is fraudulent. The victim reasonably relied on the statement when they made their decision to contract. There is an intent, in some cases, to deceive those people who are trying to buy the product. And then there's reckless statements intended to induce the victim to contract or some kind of injury. In other words, there's pressure that's been put on to get somebody to agree to sign something. To constitute misrepresentation, the statement must be one of fact rather than opinion. All right, three situations where disclosure is required. Where there is a statement about a material fact that omits important information, meaning, like, if I'm trying to sell a vehicle and I don't have my VIN number on the car, that is a very important fact. And it's, we've got to have disclosure of that. When a true statement is made false by subsequent events. A great example of this is when my parents bought a Jeep many years ago, and the Jeep itself was in great condition, but in the process of having someone go out to the lot and make sure that there was enough fuel in it and taking it to the local gas station, uh, the car was in a car accident. And thus, that might be a situation where you think you're buying a car that's not been in an accident, but then it is in an accident, whether or not you would want to contract. Some people would want to back out of that situation. Anyway, when one party knows that the other party has made a basic mistake, rather than mistaken, that would certainly be a situation where disclosure would be required. So, fraud and remedies for fraud. Fraud is based on misrepresentation, the intentional misrepresentation of an existing or important fact. And to prove this, you need two elements. You've got to have an intent and an injury that's involved. Five elements of misrepresentation also constitute the things that are used to determine fraud. And if fraud is proved, then the victim can get remedies beyond rescission, such as some kind of compensatory or punitive damages, as a way to kind of punish those people who were involved in that. All right, thank you very much.